This panel is dedicated to this topic, which is actually comes up frequently at our summit. The securities class action litigation continues to cause huge burdens for business, and the Supreme Court had an opportunity to improve the situation earlier this year with the Halliburton case, but I think the court largely preserved the status quo in its ruling and wasn't all that I think many of us had hoped it would be. Today's panel is going to address the post-Halliburton environment for securities litigation, while also touching on new issues, like the battle in Delaware over fee-shifting bylaws, which is a fairly intense battle that is underway. To moderate the panel, we're pleased to have Jeff Peck with us today. He's one of the most experienced, knowledgeable experts in town on civil justice issues, going back to his days as staff director for Senate Judiciary Committee under then-Chairman Joe Biden. He's been at the center of many civil justice reform debates over the course of the last 2 to 3 decades. He currently heads the financial services and financial markets practice for Peck, Madigan, and Jones, where he works on issues such as antitrust, cybersecurity, the Foreign Corrupt Practices Act, financial services regulation, and of course, securities litigation. So, Jeff, the floor is yours.
Great. Thank you, Lisa. Good afternoon, everyone. As they do every year, ILR's certainly put on a great summit so far, and I think you're in for an equally compelling and informative afternoon. As Lisa mentioned, I have the privilege of moderating this panel on, as we've called it, as seen through the crystal ball, the future of securities class actions. As many of you know, securities class actions have been a hot topic really for decades, going back to Basic versus Levinson and even before that. I wouldn't consider myself young, but for some of the younger folks in the room, we trace our beginnings on the topic back to the Private Securities Litigation Reform Act, which had its genesis in the early 1990s and culminated in Congress enacting the PSLRA over Bill Clinton's veto in 1995. And in fact, that was the only veto override that Bill Clinton experienced during his 8 years as president. And that landmark legislation, as many of you know, established tougher pleading standards. It introduced proportionate liability to replace joint and several liability, and it also introduced a number of new requirements for plaintiffs in securities class actions. Now, one of the consequences of that was that many securities class action plaintiffs' lawyers wanted to escape the new strictures under the PSLRA, so they moved to a new jurisdiction, and that was state courts. State securities-based class actions were not very common in those days, but with the PSLRA, the trial lawyers, who are a creative bunch, decided to bring a bunch of cases now starting in state courts. Congress, a couple years later, in the Securities Litigation Uniform Standards Act, reacted to that by imposing some new rules to prevent the shift from federal to state court that they were seeing, and to prevent certain state securities class action lawsuits alleging fraud to be used to frustrate the objectives of the PSLRA, which, as I mentioned, had been enacted a couple years earlier. But of course, the trial lawyers, as Tom Donahue aptly described them this morning or at lunch today, are an aggressive and innovative group, and efforts continue to this day, as they have since the enactment of the PSLRA and the SLUSA legislation, to get around those statutes, and we continue to see real abuse of the system. As Lisa mentioned, many of us who work in this arena were hopeful that the Supreme Court would take a major step in curbing the abuse in this area in the Halliburton case and in taking up and largely dismantling fraud on the market. But as you know, that did not occur, and I think the most generous interpretation of what the court did was they took a middle ground. But I think realistically, we're going to talk about some of that today. The reforms that many were looking for simply did not materialize at the court. So here we are today looking at the post-Halliburton landscape. We've got a great panel to discuss securities litigation post-Halliburton, potential reforms, as Lisa mentioned, the very hot issue of fee shifting that's going on in Delaware, and also the real-world effects of securities litigation on corporate governance. So just quick introductions of our panel. I think everybody here knows Paul Atkins. I've had the privilege of working with Paul on a number of issues over the years. He's the CEO of Potomac Global Partners. I first got to know him when he served as a commissioner of the SEC for 6 years between 2002 and 2008. Paul has vast experience in pretty much all areas of securities law and litigation related to it, and regularly consults on a wide range of financial services and capital markets issues. Next is Carol Zacharias, who's Executive Vice President and Deputy General Counsel for the ACE Group, which is one of the leading insurers in the world. I think I would say the leading insurer in the world, since ACE is a client of our firms. So I just want the record to reflect my views about ACE. Carol is really a corporate law guru with terrific knowledge and understanding of commercial risk and liability issues, and I think you will really enjoy the data and the discussion that she will bring to the table today. Last but not least is Allison Land, who's a partner at Skadden Arps. Allison has a very diverse practice that encompasses M&A work, joint ventures, securities, and Delaware corporate law. In fact, she's a real expert on Delaware law, and given the developments in the world of bylaws and charters in Delaware, we're fortunate that she can lend her expertise to us today. So we're going to start with Paul in a second, and then turn to Carol and then Allison, and hopefully leave some time for questions, although I think I will just say that we're not going to take any questions about teachers' unions for the rest of the afternoon. Although my daughter does work at a charter school, and she'd probably enjoy that discussion. So with that, Paul, let's start with you.
Well, thanks, Jeff. Well, and thank you all for being here. It's a pleasure and honor for me to be here to talk about this obviously very important issue. But, you know, like Jeff said, securities litigation reform has been an issue kicking around for quite a while, and it mirrors the growth of the U.S. capital markets and the importance that companies and investors hold in them, because we attract here in the United States capital markets investors worldwide. And of course, beginning really in the 1960s, things really started taking off with more companies listing, and of course they were doing that because they found more investors interested in it. And so along with that, in the 60s came around a change in the federal rules of civil procedure, which really gave birth to the modern class action lawsuits. And so, of course, as Jeff said, that the trial bar, they are very entrepreneurial, and so class actions, of course, started to find their way into the securities area. And so then you had, a few years later, Justice Thurgood Marshall issue a very important opinion, I think, called TSC versus Northway, which emphasized the importance of materiality with respect to lawsuits and with respect to charging issuers with fraud. So you take one step forward with that, and then a couple of steps backward with, as Jeff mentioned, Basic v. Levinson in the late 80s. And I remember it kind of surprised me when here recently when the Halliburton issue came up. I keep on thinking of Basic as being so basic to securities law. I had to do a double take again when I saw that it was only 1986 when it was actually issued by the Supreme Court. But that, of course, upheld this theory called fraud on the market theory, which supplanted really I'd argue, the long-held element of 10b, which relied on the proving of individual reliance for cases to go forward. So Basic, of course, was not overturned by Halliburton, but which allows, of course, people to challenge this presumption at the inception of the case rather than waiting until the merit stage. So that's a little bit of a win, but of course not much. And so we still have all of the other elements with respect to class actions that bedevil us, the needless cost, the pressure to settle early on, and that sort of thing. So we'll see what happens, but I think it will probably take more than just one election to be able to build the possibility of major reform. So we'll see how that works in the future. Of course, what underlies a lot of the entrepreneurialism on the plaintiff's bar side is the ability to get contingency fees, which of course range from 1/4 to 1/2 of all the takings. And so it's interesting that the one contract that plaintiff's lawyers really want to uphold is not necessarily arbitration contracts or anything else, but it's those contingency fee contracts. But be that as it may, I wanted to turn a little bit to the arbitration issues because I think that is one of the next areas to play out. And we've seen some interesting developments in the last couple of years in that respect. The whole arbitration issue finds its basis in the Federal Arbitration Act, which dates all the way back to 1925. And so that was public policy that, courts are overwhelmed, judges are overwhelmed even back then, and people saw that there was a lot of merit to try to encourage disputes to be settled privately rather than taking them to the federal or even state courts. And so here a few years ago, the Carlyle Group it's a private equity group and was going to go public. And so one of the provisions of this limited partnership, it's not a corporation, but one of the provisions in the bylaws of that limited partnership was mandatory arbitration. So the SEC staff, it didn't go to the commission, but the SEC staff refused to accelerate the registration statement of the Carlyle Group over this provision, basically holding it up and pointing back to a similar case in the late 80s of Franklin First Financial Corp., which also sought back then to have a provision of its charter and bylaws requiring arbitration instead of shareholders resorting to the courts. And so ultimately, Carlyle removed that provision and they were allowed to go to market. But the SEC in its staff was relying on the other provisions, anti-waiver provisions of the Securities Acts and the Securities Exchange Act, which basically say that no one should be required to waive any rights that they might have under the securities laws. There are many other Supreme Court cases that have come down in that respect, including most recently AT&T Mobility versus Concepcion in 2011, which was a very strongly worded Scalia opinion, stating that the traditional advantages of arbitration, meaning low cost, we hope, speed, and informality, are lost in class actions, and that anti-waiver provisions, such as the one, it didn't talk about the Securities Exchange Act, but similar provisions in federal law are to go to the substantive, looking to the substantive aspects of the law, not really the procedural aspects. So then FINRA and one of its members, Schwab, were locked in a dispute in the last couple of years where in the wake of Concepcion, Schwab decided to take the Supreme Court at its word and so changed the provisions of its not shareholder agreement, but its brokerage customer agreement to reflect a mandatory arbitration provision in there. FINRA objected and saying that provision was inconsistent with FINRA rules and challenged Schwab within its own quasi-judicial system that FINRA runs. The first review board actually found in favor of Schwab because it said that the FINRA rules conflicted with the Federal Arbitration Act and Concepcion. And so FINRA then appealed to its National Adjudicatory Council. But then on the eve of the council's potential ruling on that, it had been sitting around with that council for about a year, the full FINRA board intervened and basically overturned the first decision, leaving Schwab the only recourse to appeal to the full SEC. So Schwab decided to settle instead of appealing that. So again, you see how complex this is and how we're at a point now where I think with respect to a lot of these arbitration provisions that I think a number of these can be pushed forward in light of the Supreme Court's strong emphasis on them. And in Dodd-Frank, one of the provisions, 921, basically asked the SEC to look at forced arbitration provisions. It didn't say one way or another which way the SEC should go, but the SEC did a study and looked at the pros and cons, didn't come up with any ultimate decision on that, so that's still pending. The Investors Advisory Committee that the SEC has set up pursuant to Dodd-Frank has put this whole issue on its agenda for an upcoming meeting. And so we'll see which way it goes. But I hope that the SEC will not take this up and will leave it for the courts and others to address that. Allison's going to talk about fee shifting here in a few minutes, so that's another ancillary issue that, that of course, is tied up in here. One last thing I should mention before turning over is the whole whistleblowing provision, which, of course, was turbocharged, I'll say, through Dodd-Frank. It took a Sarbanes-Oxley provision, which was enacted back in 2002, and basically put a lot more power behind it. The SEC last year awarded bounties to whistleblowers in 4 different cases. They didn't announce in those how much those bounties were, but suffice it to in one it was 14 million. So there are indications that some of the more recent ones could even be higher. So probably the aspect of the whistleblowing provision that gives me the most disquiet, I guess, is the impetus then on internal people to wait for things to grow and grow in order to be able to claim a higher bounty, because the way the Dodd-Frank provision works is that if the settlement with the SEC or the CFTC is lower than $1 million, then no bounty pertains. But if it's higher than $1 million of a settlement, then you can't participate in up to 1/3 of that settlement. And so what does that do? That really basically gives an incentive for people to be quiet, internally, not report up the chain, and then report out once it passes a certain level to the SEC. So a lot of these issues following Dodd-Frank I think are very troubling. So with respect to arbitration and this whistleblowing provision, we'll see how it plays out in the future. But I look forward to your questions and pass it on. Thank you.
Thanks, Paul. That really provides a terrific, I think, foundation and context for the issues that are out there. And building on that, let's turn to Carol now.
All right, I'm going to talk a little bit about the industry, and that is the industry of plaintiffs' litigation. Securities class actions, as someone noted over lunchtime, is a big business. There were over 3,000 securities class actions filed between 1997 and 2012. And most notably, those 3,000 cases brought in $73.1 billion. So we're talking about a rather large industry. So what I'm going to talk a little about for a few minutes is who's filing these suits, what are they getting out of the suits, and what are we watching? What is the next big thing going to be, we think, in the area of securities litigation, and what should we be watching for in these suits? So to kick it off, let's talk a little bit about frequency. There are approximately 160, 170 suits filed every year for the last few years. It appears to be down from prior years, but it's not. Why isn't it down? Because the number of listed companies is down by 46%. So you have a pretty static number of suits being filed, and yet you have 50% or 46% fewer companies to sue. Net, the suits are going up. And we see that if you take a look, well, let's see if I can go backwards. If you take a look at your odds of getting sued. If you were a publicly listed company years ago, you had a 2%, and before 1997, a far less than 2% chance of getting sued. Today, 2013, 3.4% chance. Now, that doesn't sound like a lot, but we're going to get into severity in a minute. That means a lot. And if you're a Fortune 500 company, that number is much, much higher. So we do see frequency, and we do see the ability to get sued a little bit too often. What are they suing under? Where do they bring these suits? How do they bring these suits? The granddaddy of them all is securities, section of securities law is 10b-5. It's securities fraud. That's what you read about. That's what you hear about. It's a material misrepresentation or omission in connection with buying or selling stock. It's classic securities fraud. 84% of these cases are about 10b-5, securities fraud. You may see some Section 11 and 12 claims, that's registration statement or prospectus liability, meaning someone puffed too much, misrepresented something, there was a material omission, things like that. And those are in different percentages. But the big one is 10b-5, securities fraud. Now, why do we care about that? Because you see that in 97% of the cases. And they're very, very expensive. But how expensive they are depends on the plaintiff. Years ago, you had private litigants. Today, you have private litigants that are institutional investors. 43% of the suits brought in 2013 were brought by these institutional investors. Why do we care about that? Because they're very expensive. If you have an institutional investor as a plaintiff, as a lead plaintiff, the average settlement is $23 million. The average settlement is 23. Without that institutional investor, the average is $3 million. Why? They pick the bigger cases. They have to go after the big ones. They have an obligation to their investors. They take these cases very seriously, and they are responsible for the outcome. They have someone to report out to, if you will. So there's a lot of logic here, but the bottom line is you have many cases being filed. You have many cases being filed that are costing a lot of money. What are we talking about in terms of a lot of money when we break it down by statute? Well, if it's your 10b-5 case that I was talking about, and that's all they're suing over is 10b-5, it's only $6.8 million. But if you wrap in a public offering by the company, either an initial public offering or a secondary or third, whatever public offering, it goes up to a median of 11.7 million. Averages are much higher. So the cases are very, very costly. Now, why do we care about that? Because there are more and more IPOs. 2009, post-recovery, 41. 2013, 157. So you are going to see, possibly, Section 11, Section 12 claims of misrepresentations and omissions. You are going to see them wrapped around with your basic 10b-5 case. Why? Because when you do an initial public offering, you have to go on road shows. You have to file a registration statement. You have to create a prospectus. And everything in there is about a representation, and there's the possibility of an omission. So these are the breeding grounds for litigation, and they're the breeding grounds for the most severe type of litigation. So watch that space, the IPOs. The second trend we're worrying about, mergers and acquisitions, something near and dear to many of your hearts. When you have an M&A, 94% of the transactions result in shareholder actions. Some result in 21, some result in 16. This is the business that we were talking about a little bit over lunch. There's an average of 5 lawsuits for every M&A transaction. That's big business. That's a big thing to watch. So IPOs and mergers and acquisitions. What about Halliburton? What are we expecting to see as a result of Halliburton? Well, Halliburton was all about misrepresentations, alleged misrepresentations, which is 97% of the cases that we already talked about. What do I worry about in terms of Halliburton and what it means in the next few years? A couple of things. First, Halliburton brings that discussion of whether or not the representation impacted the price way forward into the class action stage, certification stage of the case. As early as the class action certification stage, we are now confronting the possibility of a mini trial on damages. What did you say? When did you say it? What did you expect? Did it affect the price? We're going to be bringing in experts on the defense side to show it didn't affect the price. We're going to have to bring in experts, obviously, then on the plaintiff side to show it did affect the price. And in spite of any subsequent discovery stage, you will have information released at that stage to talk about the facts. Did it affect the price? You're going to have facts. You're going to have information produced. Then you're going to have a mini trial, right? And if the plaintiff succeeds and gets through that class certification, they have more information that they've ever had before that early on in the case. Our case settlement's going to go up. Is it going to be higher than $23 million? If everyone in this room won a class certification after fighting and fighting and fighting with experts, you'd think you'd ask a little bit more in your settlement, wouldn't you? And that's what we're worrying about. So we know that our costs are going to go up for the class certification defense. We know our costs are going to go up for the class certification expenses, the war of the experts. And we also are concerned about that earlier production of information leading to higher dollars paid out at the end of the day. So what's after Halliburton? SEC enforcement, another trend. The SEC has been very bold and very, very clear that they are ramping up enforcement. They've gone from 664 enforcement actions back in 2009 to 755 in the last fiscal year that was just announced this past week. So why do we care about that? We're talking about private securities class actions. Because every time there's an SEC case, you see a higher value to the concomitant concurrent securities fraud class action. It's more expensive to settle. It's a much more difficult case. Why? Because you may have a stay in discovery in that private securities class action. You do not have a stay in the federal prosecution, right? So all that information comes forward and can be used to embolden the plaintiff. It is a very difficult and very tenuous road that you're on when you are handling litigation on many fronts. Why do we care about that? Because we, as insurers of private individuals, the directors and officers, are very concerned about three things that the SEC is saying. The first thing that they've made it very clear is they're going to look first at individuals. That has been a phrase used consistently. In the old days, they would go after the company. And if they found information, they would then blend in the directors and officers as defendant, right? Nowadays, they have said anyway, we are going to look first at the individuals and move outward from there. That's a concern. The second thing they're doing is, of course, the admissions policy, right? They're going to require admissions of transgressions in cases that are egregious enough or have had a broad enough effect that they really want to deter the activity in the future. Well, anytime anyone is asked to admit to egregious wrongdoing, you have a couple of problems. First, can your company still indemnify you under Section 145 of the Delaware law? Did you really act in good faith in a manner you reasonably believe to be in the best interest of your company when you admittedly did this terrible act and you knew about it because it's right here in the pleadings in the settlement agreement with the SEC? Second, if your company can't indemnify you, can your insurance carrier indemnify you? There are conduct exclusions. We don't want to cover criminals. It's not good public policy. And in some states, it's against public policy, even if we wanted to. So can you get insurance if you've reached that level of admissions? Luckily, the SEC is not there yet. They had a dozen cases in the last fiscal year involving admissions, and they are not at that high level just yet. But that's a concern to watch for, so watch that space. The third thing we're watching for is the increased use of penalties. Why do I care about that? Again, we're talking about private securities litigation today. Well, anytime you have an SEC that is trying to go after increased penalties, they're going to be going after increased information, increased discovery, to really get to the information, the meat that will justify an enormous penalty award. That will have an adverse effect, potentially, on the concurrent collateral private securities class action. So watch the space of SEC enforcement in addition to IPOs and mergers and acquisitions. That's something that could ramp up our frequency and our severity. The next thing we're really watching is cyber. You cannot pick up a newspaper today and not see some announcement of a company that's been subject to a cyber attack. Now, why do we care about that? Because in the last couple of years, there have been various things that have come out about what should a board disclose in their 10K about their cyber exposure. If it's material enough and it could affect the company more significantly enough, if you will, they have an obligation to disclose it. They may have an obligation to quantify it. And when that cyber attack hits, if it has an effect on their financials, why didn't you tell me that could happen? If you did not have a cyber czar and you should have had a cyber czar, if you didn't have the proper technology and you should have had, what did the board know? What did they do? Did they breach a fiduciary duty? State case, derivative action, admittedly not a federal securities class action. But in those situations, we have seen derivative actions so far. Why only derivative primarily? Because you haven't seen enormous stock drops. It's not as if you have a merger and acquisition or an IPO. Something happens and bang, stock goes down by 50%. We are starting to see that though. As shareholders are getting more concerned, watch that space. The last thing I'll mention on cyber is that we do have guidelines or standards that are now being issued. For example, the NIST Cyber Framework, just put out this February. It tells a company perhaps common language they can use and common approaches they can use to prevent a cyber attack. You're all directors in a company. You get sued. You get sued because you didn't take appropriate steps to prevent a cyber attack. What are they going to do? They're going to bring out this information. It's great if you followed it because you can show that it was part of due diligence. But if you don't happen to, if you've not happened to have followed some of these, is it going to come back to haunt you? So there's a good and there's a bad to everything that's going on right now. But cyber, all up, watch that space. You're going to see some federal securities class actions, and it's not going to be easy. The last two slides I'll share with you are about what industries we're watching. What are we really concerned about? Oddly enough, it's really not financial institutions. They've had their day with the latest crisis, and those cases are sort of filing out of the courtrooms and subsiding. The ones we're really watching are the pharmaceutical cases. The number of settlements, as you can see, 94, and the median value is $10.3 million. That's far above the other industries on this list. The other one, tech. Tech is always on this list for many, many years. It went down off the list with the financial crisis for obvious reasons, but usually it's on the list. 324 settlements between 1996 and 2013. That's a lot of settlements. $12 million as an average. So the frequency is there and the severity is there. Why the concern about those two beyond what you see here is this. When you look at all the different industries, take a look at the average filings from 1997 to 2012. 37, 17, 25, 21, but look at consumer non-cyclical, 45, right? The average is 45. If you look across that, and what's in consumer non-cyclical includes the pharmaceuticals and the tech. So we're looking at an area where there's a high frequency and a concomitant high severity, and then you're looking at litigation on top of that. So these are the industries we're watching. So those are the trends we're concerned about. We're concerned about frequency in the face of declining companies on the stock exchange, although there were 5 more last year than prior, so we're finding a little bit of an uptick. We're concerned about the severity, 23 million. We're concerned about IPOs. We're concerned about mergers and acquisitions. We're concerned about the SEC enforcement spillover effect, and we are certainly concerned with certain industries and cyber. So that's kind of the trends we're looking at, and that's what we're concerned with. So with that, I'm going to turn it on over.
Great. Carol, thank you. That was remarkably informative, and I know you probably don't have a ton of spare time, but I think turning that deck into an article would be an incredibly informative and helpful exercise because, particularly as with the Senate possibly changing, I think there's going to be a very fresh look, and we'll try to get to this in the discussion, at securities litigation reform in the next Congress. And I think the kind of data that you have and the sense about the trends would be remarkably informative to a wider audience. One of the areas that is really hot these days that probably doesn't get the attention it deserves is what's going on in corporate governance, and specifically with respect to bylaws that relate to fee shifting and to forum selection. So that is an area that Allison is a real expert in, and so we'll turn to you to cover those issues and related ones.
Okay, thank you. So now that Carol's gotten everybody in a panic, I'm here to hopefully tell you about a couple of mechanisms that have been developed recently to help minimize the adverse impact on corporations of the litigation. Not all of the types of litigation that Carol described. These are primarily state law claims, although, as Jeff was saying earlier, some of the securities litigation is being brought in state courts. This would focus a lot on the M&A related litigation and other state law claims that are brought by shareholders. Okay. Do you know how to make? Green. Okay. So the first one is fee-shifting bylaws. What fee-shifting bylaws are, for those of you who may not be aware, are provisions in a corporation's bylaws, or it could be in the charter, although the ones that have come up recently have primarily been in the bylaws, that require shareholders bringing claims against the corporation to pay the corporation's expenses, legal fees and other expenses in defending litigation if the shareholder is unsuccessful in bringing those claims. And this runs counter to the American rule, which typically says everybody pays their own legal expenses. This is more in line with the English rule where the loser pays. And this is a relatively recent phenomenon, and the first case that decided whether these things are valid, these provisions are valid, is the ATP TOR litigation that was just this past May, where ATP TOR was a Delaware non-stock corporation, so it wasn't a public company. It's actually a member corporation that runs the global men's tennis tournament. And there was a lawsuit brought by one of its members against the corporation that was filed in federal district court in the District of Delaware. And the plaintiff there lost the litigation, and the corporation tried to enforce its fee-shifting provision that was in a bylaw. That bylaw had been adopted by the board without member approval. And it wasn't in the bylaws when the corporation was first formed, but was put into those bylaws subsequently by the board. And the plaintiff obviously wasn't very happy about having to pay the corporation's fees and challenged the validity of that bylaw. The district court certified the question to the Delaware Supreme Court, and the Supreme Court came back and said, yes, fee-shifting bylaws may be lawfully adopted by a board as long as the charter of the corporation permits the board to amend the bylaws, which the charter did in this case. And so, generally speaking, contracting parties can modify the American rule and require the losing party to pay the prevailing party's fees. And a couple of notes that the court made was not in light of the facts of this case, but bylaws like this could be unenforceable if they were adopted for an improper purpose. And also the standard, again, this was just questions that were certified to the Delaware Supreme Court without having to decide the facts, but the standard here was, in this case, the plaintiff obtained no relief. As you can imagine, there may be situations where some claims are won and some claims are lost, and that might get a little bit more tricky. However, there was a lot of media attention and commentators who commented about this opinion, and there was a lot of uncertainty after the decision, one of which, and the biggest of which, was, well, will this decision apply to stock corporations, and most notably public companies, and as you know, many of whom are formed under Delaware law. And what does it mean if there's an improper purpose? What kind of bad act would the board have to have done in order to invalidate these fee-shifting bylaws? So the current state of play, well, since May of this year, we've got at least 24 public companies that have adopted some form of fee-shifting provisions, either in their bylaws or charters. There is a continuing, this is very recent, there's several IPOs right now where they're pending, and the organizational documents do include these fee-shifting provisions. And one of the things that will be interesting to see, as Paul had pointed out with respect to the Carlisle IPO with the arbitration clause, it will be interesting to see if the SEC takes any action in connection with declaring those registration statements effective. In other words, sort of forcing the corporation's hand to remove those fee-shifting provisions. There's a potential Delaware legislative response, which I'll describe in a moment, as well as an SEC Investment Advisory Committee that's reviewing the effect of these provisions and whether any federal response is warranted. In fact, there were just hearings just a couple weeks ago. In addition, the proxy advisory firms have weighed in. Glass Lewis hasn't officially published its position and is doing so on a case-by-case basis. Same with ISS. However, we're aware of at least one situation where ISS recommended against the reelection of directors who had, among other things involved in the situation, unilaterally adopted a fee-shifting provision. It's also signaled, but hasn't officially come out with an announcement, that it would recommend against the reelection of directors who unilaterally put in fee-shifting provisions. And when I say unilaterally, again, I'm talking about an amendment to the bylaws by the directors without stockholder approval. And so the next thing I want to describe briefly is the proposed legislation by the Delaware State Bar. As I said earlier, the ATP TOR decision was in May of this year, and following that decision, the Delaware State Bar Association proposed legislation which, if adopted, would have limited the ATP TOR decision just to non-stock corporations. So would have prohibited stock corporations from adopting fee-shifting bylaws or any other charter or bylaw provision that imposed monetary liability on stockholders. And the goal was to avoid undermining the limited liability protection of Delaware corporations. And proponents of the bill said that the bill would eliminate the chilling effect that these bylaws would have, and therefore handing over the keys to the corporation to management. You know, one of the things I heard in several of the speakers today was that there are valid stockholder claims that can be brought. And so the question is how to delineate between valid stockholder claims and those that we've sort of been talking about on this panel. One of the arguments in favor of legislation by Delaware opposing the bill is that Rule 11 provides, Rule 11, which provides sanctions to bad faith litigation, provides protection for really those bad faith situations. However, as we know, Rule 11 is rarely imposed. So the reaction to Senate Bill 236, the ILR itself came out with a letter urging the Delaware legislature to defer consideration of the bill and to allow for a more robust discussion. And one of the things that was pointed out is that reducing frivolous M&A related litigation is an important policy goal. I don't think anybody can argue with that. Other commentators felt that the bill was too broad and that perhaps it would be best to allow corporations, with or without stockholder approval, to design well-tailored fee-shifting provisions that balance the interests of the stockholders and the corporation. So the result was that, indeed, the bill has been deferred. The General Assembly in Delaware passed a joint resolution in June urging the Delaware State Bar to continue examining the permissible scope of not only fee-shifting bylaws, but other bylaw and charter provisions that affect the conduct of and the forum for litigation for Delaware business entities. And that examination by the Delaware State Bar is underway. And a number of the issues are whether there should be a difference between a stockholder-approved limit versus board-approved. And if stockholders approve prior to an IPO, well, what happens to the public stockholders? Do they take subject to that? Or should there be some kind of requirement for post-IPO approval? And so the bottom line is stay tuned with respect to fee-shifting bylaws. It's a moving target as we speak. Forum selection bylaws. Forum selection bylaws have been around for a good couple of years now, so it's a little bit older than fee-shifting bylaws. But they were first in 2012 and 2013 put into place to address the problem in multi-jurisdictional litigation. By multi-jurisdictional litigation, what I mean is one of the problems with lawsuits being filed not just by one plaintiff, but by multiple plaintiffs in multiple state courts. You see some studies that show, as Carol said, more than 90% of M&A deals attract litigation. And for deals with a value of over $1 billion, there is an average of more than six different lawsuits challenging each deal. So you're fighting a suit in California, in Texas, in Delaware, et cetera, hiring different law firms to fight each one of those litigations. And the exclusive forum bylaws try to counter that by requiring for, again, this is stockholder litigation, to require all stockholder litigation to be brought in a specific forum, typically the state of incorporation, although not necessarily. And some commentators have noted that this is the elegant solution to multi-jurisdictional litigation. It's okay if I have to fight you, but just let it be one fight. And in fact, this came before the Delaware Supreme Court, Delaware Court of Chancery in the Boilermakers case where the forum selection bylaws were challenged. They had been adopted by both Chevron and FedEx, and in two cases that had been combined. The then Chancellor, now Delaware Chief Justice Strine, upheld the bylaws and found that, that as a matter of Delaware law, that a corporation is free to require litigation to be brought in a particular forum, as long as enforcement is not unreasonable or unjust given the facts of the situation. So leaving open the question that if done for an improper purpose, the bylaw could be overturned. Generally speaking, the bylaws are appropriate. The scope in the case that was approved, though, is limited to shareholder derivative suits, internal affairs, fiduciary duty claims, and claims relating to corporate law, charter, and bylaws. So it's not every litigation, but just stockholder litigations really relating to the corporation's internal affairs. The case had been appealed, but the appeal was eventually dismissed by the plaintiffs. But as I said, the then Chancellor who authored this decision is now our Chief Justice, so I'm not sure that we're actually going to see a case make it to the Delaware Supreme Court. So interestingly, there have been 2 cases that have addressed what I'll call cloudy day adoption of forum selection bylaw. In other words, putting in a bylaw, the directors putting in a bylaw on a day when they were approving another transaction, an M&A type transaction. In one case, an Oregon State Court refused to enforce a bylaw that was designating Delaware as the exclusive forum when that bylaw was adopted on the very day that they approved an M&A transaction. And the court there said that you were basically forcing the shareholders to accept the bylaw. That decision was in August of 2014, so just this year. 1 month later, our now Chancellor, Chancellor Bouchard, in Delaware, addressed the very same topic in the First Citizens Bank Shares case and upheld the bylaw. And in fact, imposed the very deferential business judgment standard to its review. And interestingly, this was a Delaware corporation, but instead of choosing Delaware as the exclusive forum, the bylaw provision chose North Carolina, which was the state in which its principal place of business. But nonetheless, the Delaware Chancellor upheld that, notwithstanding the fact that, again, it was adopted on the same day that an M&A deal had been approved. But there, the Chancellor said that, absent specific allegations of impropriety, we're going to permit the board, under the business judgment rule, the flexibility to adopt these types of provisions. What do the proxy advisory firms say? Well, they're not very favorable to these types of provisions. Glass Lewis is generally withholding votes against the chair of the not all of the directors, but the chair of the governance committee when the board adopts a forum selection bylaw without stockholder approval. ISS is making its recommendation on a case-by-case basis, and it does take into consideration whether the corporation has in fact had difficulty and a lot of expense in connection with multi-jurisdiction litigation. So they'll look at your public filing and see if there's any real need for this type of provision and making the decision. So where are we with respect to forum selection bylaws? Well, again, these are relatively recent, within the last couple years, and as of this month, we've got 104 of the Fortune 500 and S&P 500 companies that have adopted them, and that's up from 38 companies just a year ago. And in total, at least 394 publicly traded companies have adopted an exclusive forum provision. And the vast majority, 348 of those, are in the bylaws only, so those are board-adopted provisions. So in summary, it appears that exclusive bylaw provisions are not going away. And again, as I mentioned earlier, this is the focus of the Delaware State Bar Association review, but I think this is one tool that you will see increasing use of, and as I said, at least this way, there may still be stockholder litigation, but at least it will just be one challenging each issue.
Great, thanks, Allison. Let me start with you, just to pick up on what's going on in Delaware. 2 questions. One, what's the time frame that you see in terms of the Delaware State Bar and the legislature revisiting the fee shifting piece of this, because so many people are watching with such great interest, and as you noted, the chamber played a huge role back in the spring to forestall a kind of rush to judgment by the legislature. And then second, one of the areas that Carol, I think, rightly mentioned as an area of concern is M&A. I mean, the fact that there's 5 lawsuits per M&A transaction is quite remarkable. One of the issues that I know surfaces in Delaware and that a lot of people are concerned about is this whole question of appraisal rights and some institutional funds, mostly hedge funds, bringing these cases. And I know companies who are dealing with transactions end up settling like they do in a lot of this sort of litigation. So do you think the Delaware State Bar and the legislature, as they look at fee shifting, will also take a look at the problem in the appraisal area, or are they exclusively focused, do you think, on fee shifting?
So to answer the first question, the study is underway as we speak. The normal legislative process would have, just as it was this year, in June, the legislation being brought before the General Assembly. So although anything can happen and who can predict, and maybe it doesn't even happen this year because it is a hot topic, I would expect that given normal circumstances, that's when something would be proposed. And with respect to appraisal rights, yeah, that's actually because I thought that was sort of out of our scope. I didn't mention it before, but the joint Senate resolution that I mentioned earlier, when the fee shifting provision was pulled in June, the Delaware General Assembly urged the Delaware State Bar not only to examine fee shifting and exclusive forum, but also appraisal rights. So that is something that is also being studied by yet a separate subcommittee of the Delaware State Bar. So all of these topics are being reviewed. And again, although I can't make any guarantees and who knows what could happen, I would expect that something should be considered during the course of this year.
Paul.
One interesting thing just to point out, because I had mentioned earlier the Carlisle IPO scenario. Back in the mid part of the last decade, Delaware actually adopted a law that allowed for the SEC to, if it wishes, to certify or send issues to the Delaware Supreme Court to be judged and in sort of like an advisory opinion, a declaratory judgment type of thing. And it's, to my knowledge, it's only been used once when I was a commissioner, and so it'll be interesting. It's meant to, rather than the SEC decide in a vacuum what things should be, and especially for things that ought to be sent back to a state to decide what state law is. We'll see if the SEC, rather than going out on its own with respect to some of these issues that come up in public offerings, will send them back to the state of Delaware to be determined that way.
Let's move back up to the congressional level, and I will say carefully, since I'm a Democrat, that simply assuming for the sake of argument that the Republicans take control of the Senate, and I am willing to concede the House will remain in Republican hands. But let's say the Congress is controlled by Republicans, and let's say the relevant committee chairman were to come to you and say, look, we want to come out of the box with some securities litigation reform for 2015. Tell us what you think the top 2 or 3 priorities that we ought to look at are. And maybe, Paul, I'll start with you and we can come down the panel. What recommendations would you give them for the first 100 days, for example?
Well, as an independent, since in Virginia one can't register as for the political party. But anyway, no, it's a real tough issue because I think it depends a lot on what the makeup of the Senate is going to be. And of course, we know that the House will hopefully, knock on wood, stay about the same or increase with respect to Republicans in there. And then that whatever gets passed will be sort of a revisit of your experience back in the 80s with respect to a veto. I think things have to be done, rather carefully. And so, one could address some of the leftover issues out of Halliburton. I think those are kind of teed up and on the top. I mean, there are a number of issues I would suggest.
And just on that point, just for everyone who might not be familiar with every aspect of Halliburton, the court really did essentially invite Congress and say, look, if you want to change fraud of the market, it's for you to do, not for us to do.
Right. And then there's some other issues, I think, arising out of Dodd-Frank that I just think are screaming to be addressed. And I'd say foremost of those, the whistleblower provision and the potential for, as I mentioned earlier, for abuse of it. And then, I could go on. The 2,319 pages of Dodd-Frank are riddled with all sorts of special provisions that we'll see, whether or not they do invite shareholder litigation, among which that haven't been finalized yet, the conflict minerals issue, mineral extraction. There's so many disclosure-related things to that. And then some of the other ones like pay ratio and whatnot. It's all a plaintiff's lawyer's dream, frankly, a lot of those provisions. So I would, I would respectively submit to Congress that they ought to, pick that low-hanging fruit first. Carol?
I'd have to go with fraud of the market, Halliburton, need to clarify this. I'd also say that someone needs to be thinking about the directors and officers. And there's nothing specific I can recommend at this point, but what somebody has to think about is the following. Under most regulations now, they are trying to, let me restate that, under many regulations now, folks are trying to hold directors and officers personally liable. The idea is, you hold the board liable, the board's going to fix it. If you hold the board liable, the board will do something about it. Who's going to sit on the boards, right? So we are ramping up personal liability of directors and officers. I know some people that are involved with compliance, And there are now criminal offenses for a chief compliance officer. There's now personal penalties that have to be paid by chief compliance officers. And that's only at the chief compliance officer level. What about at the board level? So it's great to have all of these proscriptions out there, and it's great to say somebody should pay. But eventually, those somebodies are going to get darn frustrated. So somebody has to really sit back and think about what we're doing to encourage people to sit on boards, to hold them accountable, but to make it possible.
Allison?
Just to reiterate, I mean, I agree, filling all the holes in Dodd-Frank is something that absolutely needs to be done. It's going to be embarrassing. And then in terms of directors and officers and corporate governance, I'm more of a proponent of let the states regulate those and sort of leave the feds out of it. And I think that you would find a lot less of the risks that Carol was just pointing out.
Yeah,
So less federal regulation.
I agree, but also fix the federal regulations out there to date.
Repeal.
Yes.
Well, we've got 5 or 6 minutes left for questions. If we have a couple from the audience, I'm sure we can field them. I think a microphone is on its way to you. And if you would just identify yourself as you ask the question, that'd be great.
Sure. Mike McManus from Drinker Biddle. As a follow-up to Ms. Zakaris's last comments and things that you said during your excellent presentation, I fully understand and appreciate the concerns of carriers and certainly officers and directors themselves about a trend towards holding them accountable. But if I'm a shareholder and the choice is, in this situation, there really are some bad guys who did some bad things, I don't want to see my stock plunge because my whole corporation, my investment is going to be sued and everything's going to fall apart. I want those guys to go after it. Obviously, two varying positions, great tension between them. What's being done, or is anything being done to find equilibrium between those two positions?
That's my concern. I don't know that there's an equilibrium at all, and I don't know that there's anything being done to take a step toward finding that equilibrium. Right now, it's very clear that everyone in this room would want the black hats to be held accountable and responsible. There's no question about that. But when we talk about shareholder value, what's happening is that $23 million is being spent by some folks who, frankly, didn't do anything wrong. It's just that it's a sport for litigation whereby individual shareholders get back pennies on the dollars, but the plaintiff's attorney get back a few dollars more than that. And all of that $23 million comes out of those shareholders' pockets. So it's not like we're making the bad guy pay. It's we're making the good guys take money from the shareholders and hand it to the plaintiff's attorneys. Is that a successful business model for a free economy? I'd suggest not. So there isn't an equilibrium right now. The bad guys should pay. I agree. There's no question about that. What we're talking about is the other cases, and there's so many of them.
This is a very important point, and the ILR has put out a lot of written material and studies and analysis of this, that what you're talking about in this crazy system is essentially a transfer of wealth from one group of shareholders to another group of shareholders with a huge benefit to the plaintiffs' law firms, and there's not a ton of them, a handful of plaintiffs' law firms who have kind of made this into the cottage business. So you can look at the system in general and certainly there are cases of wrongdoing where the payments are, where the liability is justified, but a lot of times, as we've talked about in other areas, it certainly is the case here. Basically, the ransom note that Tom described is the request for settlement, and the people who benefit are really the plaintiffs' lawyers who have brought the law firms, not the shareholders who, as Carol rightly says, pennies on the dollar is basically their recovery. I mean, we've all gotten those notices in the mail that require you to fill out 18 pages of documents, and most people don't even fill them out. And if you do take the 2.5 hours it requires to fill them out and collect all your documents, you may end up getting 4 or 5 cents on the dollar when all is said and done.
Yeah, just to add to that as well, with respect to the SEC, and one of the provisions of Sarbanes-Oxley was called the Fair Funds provision, where the SEC can put disgorgement funds and other monies collected from individuals even into a special fund, which is then distributed to shareholders, and part of the question is to whom is it distributed. But really, I view, and I decried this when I was a commissioner, that it does become the same sort of circular thing where you're taking money oftentimes from a bankrupt company or whatever, and especially if it's a financial fraud, it's the shareholders at the time who bear the brunt of that alleged fraud that was committed. And so money is coming out of the company then to be paid back to them with all of the extra wheel spin that goes. And so some people are holding up the SEC enforcement powers and process as a way to get around the shareholder litigation aspect. I'm not so sure, because I'm not convinced that the SEC process has all the time integrity and in the best interest necessarily of the shareholders at heart.
One more question? See a hand in the back.
J.W. Verrett at House Financial Services. I'm wondering, I'd be interested to get Jeff's view of what the end game looks like on the Senate side, assuming the Senate flips, perhaps. Because on the one hand, it's kind of heartening to think about what happened in the dynamic of PSLRA, that the Democrats voted to actually overturn one of the few presidential vetoes. And of those names of Democrats, there are 6 of them still in the Senate. Some surprising names there. Senator Reid, Senator Feinstein. To me, it was counterintuitive to look those up and see those names voting to overturn the veto. So I guess the menu of options I would be interested in would be kind of like a Chinese menu, and my counterparts on the Senate side whose votes we'll need probably look more like a fixed menu at a French restaurant. So I wonder what Jeff thinks, where we'll whittle down to in terms of marginal process reform on civil litigation, defining the elements of an action in directly into the 34 Act, which we've never done, and we probably should do from both the perspective of both sides to get some certainty about what constitutes those elements in a private action. I'd be curious to know, if Jeff's best guess about where we end up at the end of the day on this process after the dance is all over.
Well, I think it's really a mathematical question in a lot of ways, which is, first of all, I think if the Democrats were to retake the Senate, this conversation takes on a very different dynamic. But let's assume Republicans take control. If there's 51 or 53, it makes a big difference, because you're still going to need, in all likelihood, to get to 60. So let's say the Republicans have a narrow margin, and let's assume, and I don't think it's necessarily the safest assumption, but you can assume you get most, if not all, the Republicans, but some of the Republicans will need some support and work in this arena. And then it comes down to that number of moderate Democrats that you can get to 60. Now, bear in mind, if the Republicans take over in the Senate, it's because probably some of the moderate Democrats who you'd be lobbying to get to 60 will no longer be in the Senate. So the group of Democratic moderates gets narrow. But you really, what we did in the PSLRA is, when the Contract with America first came out, it had, the House version of the PSLRA, as you know, JW, had a much more, was far-reaching, and there were proposals by Chris Cox at that point, Phil Gramm in the Senate, to go further than the ultimate bill went. But we still were able to sort of parrot that back, get to the 60 votes that were necessary, and then veto override in the Senate was still a pretty considerable and significant set of reforms. So, I think the more Democrats you need, the more the reforms may be, so to speak, at the margin. I think, even with Republican control, the consensus here, I think, is the biggest and most important thing we could do is do something about fraud on the market. But I know in our assessment of the possible scenarios post-Halliburton, were the court to have completely overturned BASIC, I think it was going to be hard to keep even all the Republicans, putting aside getting any Democrats. So, you're right. The specific reforms are really tied to the math, meaning, how many people do you need to get in order to get to 60? And again, query, if you got to 60, what's the president's appetite to accept some sort of reform. You can make the case the last couple years of his administration, it's easier for him to accept them than in other years. You know, you could also easily make the case that he's not going to tolerate or endorse you know, either major changes to Dodd-Frank, although certainly we're not even talking about the most major changes you can make, or serious reform efforts in securities litigation. But I think to have that problem and be worried about what the president will do with the bill is probably a good thing, would be a good discussion to have if we can get to that point. So Lisa, I think that's, I want to thank the panelists. It was really, really great discussion.